Hello, I'm Antonia Layard, and as part of this stream on Jerzy Priban's research handbook on the sociology of law, I am doing a brief talk about property, introducing some of the ideas in the chapter I wrote for the handbook on property, as well as bringing in a bit of new work on public space I'm undertaking at the moment to see how some of these ideas and frameworks match up and whether they help us understand property at all. So one of the implicit, rather hidden arguments in the chapter is that property from a socio-legal perspective is difficult to understand as unitary, as singular, and it's also difficult to proceed on a basis from abstract first principles. I didn't necessarily want to make that a full-out claim. I think most socio-legal writers and most people reading the handbook would be quite comfortable with that statement. So for me, property, there are core traits, and these are shared often, but it's a bit like a Venn diagram. Not all are shared by all at the same time, though there are definitely themes. And again, while I didn't want to foreground my definition of property in the chapter, as it was more about how other people understand property from a socio-legal perspective, it might be helpful for the sake of this presentation just to put my hand up and say this is how I understand it, this is my definition, which is that property can be understood as a bounded space within which owners have protection, exercise some authority, acquiring status and responsibility. And there are four themes that I work through, four parts of a framework to understand property from a socio-legal perspective, which are property as an institution, property as practices, property as object, both property as object and property and possession in particular, evidenced by objects. And finally, property as an idea. It's a really powerful imaginary that continues to pattern our thinking. So to begin with, property as an institution for the purposes of public space, and by institution here I mean government. There's obviously long links between property ownership and government. We can look at Adam Smith and other writers for this, but also very practically that government has long decreed who may own property according to criteria of race or age or gender. So institutions are relevant if we want to prove particularly title, as opposed perhaps to ownership, but title in courts, and also to everyday transactions for mortgages or leases or otherwise. So property as an institution for me is very important when I come to study public space, and many socio-legal friends jest that I may be unduly doctrinal in this, but when I am on site personally, my first question is always to ask, who is the paper owner, who is the registered proprietor? Because this tells me a lot about the way the land operates, even if the paper owner, let's call them that, is missing. So their absence or their presence is usually quite determinative in understanding the role of public space. So what I've got here is a series of quotations from some empirical work we've been doing. And this first quote is about a classic retail site. And just making the point, this interviewee stressing that the security in this retail site has long determined that if you look out of place, they will ask you to leave. And the trespass license binary is alive and well. And as he says, I'm not saying any of them will do it without reason, but as soon as the reason's there, they'll jump on it. And it's the idea of because the space is semi-public, there's a certain expectation. So this also goes with practices, which I'll come on to in a minute. But the trespass license binary, I would say, is alive and well, and that's the institution of property working through public space. And this ability of the paper landowner to determine how public space is used is also evidenced in this quote, which comes from a land manager in the public sector, talking about how he likes to preserve his lawns and their lawns. So whether it's public or private, the idea of control and also controlling use comes through very prevalently in our interviews. Sometimes public sector employees are alive to competing needs, And this is an example where skateboarders were redirected to a certain point where they weren't getting in the way of an area of land which had commercial opportunities for the council. So there's quite a lot on skateboarding in our data, and that is largely because it's so located within Bristol. But I think skateboarding is often an indicator species, a bit like protest, for public space. So here we see a public landowner, a land manager, actively trying to accord respect for different uses of public space. On private sector estates, there's much less concern about the interests of others if they don't accord. So one land manager saying, I don't really want balls thrown around, no sports, however gentle, and another saying no ball games, no skateboarding, no BMXing, because it damages the facilities we have on site. So whether or not it does damage, there is a perception that it's damaging. There are also perceptions of noise. But what is clear is that the land managers we talked to thought it was within their remit and also sometimes part of their identity. We have talked to them and they think if they are by nature more cautious, then they have more powers to exclude. And I think often when we talk about property, we don't talk as much about responsibility as rights, but working on public space, the potential of liability, of harm. We have quite a few interviewees talking about what happens if someone gets hit by a skateboard. So that aspect of land management looms very large in daily life, but perhaps we don't think enough about when we think about what property is, that it is also a form of distributing property. There's a nice paper by Larissa Katz on this, which is cited in the chapter. And I think responsibility for health and safety, for taxation purposes, is one of the key aspects of property. So to move on to property as practices, this is where perhaps as socio-legal scholars we feel particularly comfortable. We talk about social norms and customs, so citing Sue Bright, Sarah Blandy and Sarah Neal's work there. And in particular, we can see that in terms of public space, there are ways in which most of our interviewees felt that public space could be enjoyed. So this is a private sector land manager interview too. And she says, down by the water is a popular spot. People have their lunch there. So being outside and having lunch in these developments, we saw this quite often in our data, that this was very much an acceptable use of public space. And there's no civil disturbance and they're being civil. So for her, the key word was civil. So I know the estate haven't any problem with people coming and having basically a good time and having picnics and conversing and things like that. But it is a fairly sedentary image of the type of activity you're allowed to do in public space. In this case, privately owned public space. So all of these pictures are of Bristol, as you may have realised, and there are in Bristol particular norms and particular cultures, and I think that's one of the dangers with doing research in a place which is quite grounded, that what may be acceptable in Bristol probably wouldn't necessarily be acceptable in all places. But there are perhaps shared imaginaries, shared practices, norms and customs that we might think about both in terms of what that tells us about property as well as how we might think about public space. And many socio-legal scholars here would tend to Robert Ellickson's work, the ranchers of Shasta County, who were all landowners, and in some of his work on law and economics, he writes that a norm tends to enhance the welfare of the members of a group that adopts it. And one of the points here being is that if you have shared norms, you may well develop into property or something akin to property, and that would be the claim in Ellickson's work. But when Ellickson talks about panhandlers, he comes to a quite strikingly different conclusion. And here he says that disorderly people are not the only citizens with liberty interests at stake. And he distinguishes people living on the streets, homeless people, from pedestrians of ordinary sensibility, not to mention the rights of the unusually delicate. And so here, rather than talking about shared norms, he very strikingly talks about zoning specifically for certain places, which he calls Skid Row. So he comes up with a very regulatory system where there aren't the same shared values as you might see, for example, in Shasta County. And this brings me to Amelia Thorpe's lovely new book and all her work on Parking Day. And Amelia has shown, I think, how property as we understand it might be built at street level. Amelia is a much more optimistic person than I am. It's one of her many wonderful traits. And her view is that by the process of building a park, participants say that their strength of ownership is strengthened. The performance of legality in Parking Day is itself productive. So while nobody assumes that you actually own the property when you pay the parking meter, that this contributes to ownership. And I think there's something there about the difference between titles and ownership that the most doctrinal and property theory of scholars would agree with. But for Amelia, this is about how practices can constitute informal ownership as well as formal. So in public space, when we've got these shared interests, can we build that kind of ownership? By nature with public space, you've got to be inclusive. And it's one site in particular, and I do worry slightly that this one site is very much colouring the research that we've done. It's such a problematic site, but there are issues about male intimidation of women through all sorts of ways, through people asking for money, through antisocial behaviour, and also to men taking their tops off and sunning themselves in a very multicultural city, and how appropriate that may feel. And what we have here is we have rules, we have behavioural contracts, but they are different in different places. So this facilitator of people with complex needs talks about how you might put your feet on the furniture in one street where he works a lot, but you wouldn't in other parts. So a lot of these rules, these contracts, vary by location. And this is also what Amelia finds, that some locations lend themselves to Parking Day more easily than others. Another of our interviews on this one particular site, which is quite contentious, distinguished between the authoritarian view, particularly from the council, top down, this is how you will behave in the space, and how little effect that had from a bottom up, because there was a code amongst the people there. And sometimes this code was random, and there was different people turning up who took over the space through their voices, through their behaviours, and really made it very uncomfortable for many people. In particular, when the squatters came in Bristol with one political agenda and the spice users were on the right-hand side. And slowly the squatters got pushed out by the users of substances. So I haven't got time here to talk about property as object, but we can see that practices may give us property, may be some form of governance of space, and the materiality of that governance can also have its effects. I'm going to talk about this when I do a session with Sarah Trotter and Amelia Thorpe on the law of place, if you're interested. To conclude, this brings us to property as idea, which is the final strand in the chapter. And who better to turn to than Margaret Davis, who tells us that property is a socio-legal artefact that obtains at least some of its power by being naturalised, that the idea of property is sustained in part because an ingrained imaginary invests it. So property's idea is quite a popular concept within socio-legal studies. In our public space work, it's quite a long quote, but in this very, very contested site, what I found extraordinary is that the police officer didn't feel able to use the powers of policing that were available. Instead, ultimately, it was whether or not the council wanted to evict the users. That was where ultimately the power lay. And in this quote, with a surveyor from the new developing project in Bristol, very commercial, very design-led, initially very keen on the idea of public space, but when pressed, felt that if it was going to affect the asset value, so the idea of property as an asset value in financial terms, then that would be a problem. So we could think of this in terms of the bundle of sticks, but for him it was very much about how much the property is worth and that public space might detract from that financial value. So that is it. Thank you very much for listening. Those 4 aspects of property as institution, as practice, as object and idea in relation to some new work on public space. I very much look forward to your questions. Thank you.